Substitute decision-making is a generic term that is applied to various types of legal authority that confer the power on one person to make binding financial, healthcare, or other decisions for another person. These include guardianship, financial powers of attorney, healthcare advance directives, mental health care advance directives, healthcare representatives, representative payees, and trusts. Substitute decision-making is sometimes called surrogate decision-making, and the people who have the authority to make decisions for other individuals are generally called surrogates. You are watching one in a series of videos on substitute decision-making by the Disability Rights Network of Pennsylvania and the Developmental Disabilities Council. The people who appear in these videos are individuals with disabilities, family members, and advocates who are interested in and impacted by these issues. This video addresses common questions related to guardianship. Everything else. All right, great. Why don't we get started then? Thank you for coming. My name is Mark Murphy. I'm an attorney with the Disability Rights Network of Pennsylvania, and I'm here today to talk to you about guardianship and to answer questions that you have about guardianship. So why don't we get started? Who wants to ask the first question?
What is a guardian?
A guardian is really simply just a person who is appointed by a court. So there's a legal proceeding. It's a person appointed by a court to make decisions for someone with a disability when that person with a disability is unable to make decisions for himself or herself.
Are there alternatives to guardianship?
There are alternatives to guardianship, and that's a great question because a lot of times people don't consider enough alternatives to guardianship and assume they immediately have to move to guardianship as their form of substitute decision-making. But there are a number of alternatives, so let me just talk about some of them. The first one, which is really the most obvious, is that many people have family support, they have friends, they have advocates, they have a circle of support who can help them make decisions, provide them information and language they understand and using concepts that somebody understands. So family, friends, that circle can be an alternative to guardianship. On the financial piece, the representative payees from the Social Security Administration. If somebody's unable to manage finances and gets SSI or Social Security disability, the Social Security Administration can often appoint a representative payee if a person needs that type of assistance, and that representative payee is able to handle their financial matters. And so you don't need to have a guardian to do that. Some medical decisions can be made by what's called a healthcare representative. If a person with a disability hasn't done an advanced healthcare directive or can't do an advanced healthcare directive, the law permits a family member or somebody else who knows the person's wishes to be a healthcare representative. So that can be an alternative to guardianship. So there are a number of different ones you can have. And the important point is people shouldn't automatically assume that because their family member has a disability, even a significant disability, that automatically guardianship needs to be sought.
If guardianship is unavoidable, do I need to hire a lawyer and go to court? And how much is that going to cost me?
That's a good question because it's the very practical concerns that people have, and we often get calls asking people just on a very practical level, how do I do it? What does it cost? So generally speaking, yes, you're going to need a lawyer. Guardianship is a legal proceeding. A petition for guardianship has to be filed in the Court of Common Pleas in the county in which the person with the disability lives. And so generally, since you're involved in a court proceeding, a lawyer has to be involved. It's possible to do without a lawyer. That's what's called a pro se filing, but that's not something that's common, and I can't really say that I recommend that simply because it can be a complicated legal proceeding, one that requires time and effort and the filing of forms, and you have a hearing with witnesses, and so it really is a legal proceeding. You know, as to what it costs, that's going to vary depending on where you live and how complicated the issues are, but I think it's fair to say you should certainly not be surprised if a lawyer would want to be paid, you know, several $1,000s to handle a guardianship hearing. Sometimes you can have a lawyer who'll do it for less or sometimes more, but it can be a significant outlay of money.
Are there different types of guardians?
There are different types of guardians. There are basically 4 elements. You can be a plenary guardian or a limited guardian, and you can be a guardian of the person or a guardian of the estate. So that leaves you with 4 separate options, right? A plenary guardian of the estate, a limited guardian of the estate, a plenary guardian of the person, or a limited guardian of the person. So there are 4 possibilities. And a guardian of the estate is someone who is authorized to handle some or all of a person's financial matters, and only financial matters. A guardian of the person is someone who is authorized to handle some or all of a person's personal decisions, where you live, maybe what kind of programs you may need to be involved in. Non-financial, personal type of decisions are handled by the guardian of the person. Now, limited guardianship is something where a judge can limit by either time or subject matter the subjects that you can make decisions about. So, for example, if you're the limited guardian of the estate, you might just be the guardian for a certain period of time, or you might just be able to handle financial decisions that involve a lot of money. Maybe the person can handle smaller financial issues, but anything over $100 the person needs help with, so that your power is limited to financial decisions over $100. Similarly, with a limited guardian of the person, you may just make some decisions. Maybe the person just needs help on medical decision making or where they live, and not other types of decisions. The person is able to make those types of decisions. So you have a range of possibilities and a range of authority under the guardianship law. And what the court does is issue an order that sets all that in detail.
Is there any limit to what a plenary guardian can do?
There are. It sounds like a plenary guardian should get to make all decisions, but there are just some decisions that the law doesn't allow any guardian to make. So, for example, they're often more personal type of things. So a plenary guardian is not allowed to consent to a person's marriage or consent to their divorce. They're not allowed to consent to the sterilization of the person if that has become an issue. That can't be done by a guardian without a separate court proceeding. There are other types of things a plenary guardian can't do. For example, a plenary guardian can't admit someone to an inpatient psychiatric facility or a facility for persons with intellectual disabilities. They can't provide the consent for that. That has to be done through a separate proceeding. So while a plenary guardian can make a lot of decisions, there are some that the law just carves out and says we're just not going to allow any guardian to make those types of decisions without further court involvement.
Why do I need to show the court to get a guardian?
Well, as I mentioned before, there'll be a legal proceeding. And in that legal proceeding, you have to show that the person with a disability is incapacitated. That's the legal term, incapacitated. And what that means is you'd have to submit evidence to convince a judge that the person, because of their disability, is unable to make and communicate decisions. And that inability is so significant that their ability to make financial decisions or to take care of their physical health and safety is so impaired that somebody else has to come in and make the decision. So you have to show not just that the person has a disability, but that the disability is so significant that the person is unable to make or communicate financial decisions or take care of their health and safety needs adequately. And if you can show that, then the court can appoint a guardian. And this has to be done through evidence. You will probably have to bring in an expert, and that expert has to be qualified in the disability involved. So if the person involved is a person with intellectual disability, you're going to have to bring in somebody who has training and experience working with people with disability, intellectual disabilities. If it's another type of disability, you'd have to bring in someone who has that kind of training or experience. Another thing that the court has to consider is what alternatives are there to guardianship, and have they been looked at and have they been tried? They also will look at the person's finances, the person's circle of supports, natural circle of supports, family and friends. So they take in all of the circumstances in a person's life, and after looking at all of those things, and including what the person him or herself may say about it, if they're able to communicate that, then make a decision about whether the person is in fact incapacitated, unable to make decisions for themselves.
How quickly can I get a guardianship order if there's an urgent situation, such as I think my son's in danger or he's being abused?
That's a good question because, as I mentioned before, you have a legal proceeding, and as everybody knows, legal proceedings sometimes take a while and can drag on. But in the event of emergency situations, you can go right into court, and a judge can appoint someone as a guardian for up to 72 hours to handle an immediate emergency problem. This sometimes comes up in the context, for example, of some medical issue or something like that where somebody may need something. And then you have to show that without a decision that somebody would be subject to irreparable harm. So that's a pretty high legal standard to get an emergency guardian. So now the 72 hours comes and goes. A court's able to extend that for up to 20 more days. And so then you still have the emergency guardian for 20 more days. And by that point, what the law says is you have to go through the normal process that I described earlier, file a petition, go in front of the judge, and make sure that the guardianship is still needed. But there is a mechanism to have an emergency guardian in the event that it's needed. So you can get right into court and take care of that problem should it come up. Okay, I think that's all I have. Does anyone else have any other questions? All right, well, I'm going to hang out for a few minutes afterwards. If anyone wants to talk to me privately about any personal type of situations, I'll be happy to do that. But otherwise, thank you all for coming, and I hope our discussion was useful and informative. Thanks.
Actually, we do have a couple questions for you.
Why don't we wait till the other folks go, and then we'll talk privately. I'd be happy to handle any of those questions. After our discussion ended a few minutes ago, you had said you wanted to sit down with me and ask me a few additional questions, and I'm happy to help out if I can. So, Sarah, did you have a question for me?
Yes. I have a disability and I don't want guardianship. What are my rights?
Well, you do have rights. You have rights as a person with a disability before any guardianship is filed, and you have the right to make your own decisions to the maximum extent that you can, and to get decision-making assistance if you need that, so you can make decisions to the maximum extent that you can. If a guardianship proceeding would be filed that would involve you, you have some legal protections. You would have to be notified about the guardianship proceeding, so you could prepare. You have the right to be there at the hearing itself, so nothing would happen that you wouldn't know about. In some cases, not all, but in some cases, courts appoint lawyers for the people who are the subject of guardianship proceedings, and sometimes will even use court costs to pay for expert witness fees. And an expert witness is somebody who would come in and have to testify for you about your disability and how it impacts your decision-making ability. Even after you had a guardian, though, it's important to know that you still have the right to participate as much as possible in your own decision-making. And the guardian may have the ultimate authority to make the decision, but at the you get to articulate what you want to say, and that guardian needs to take into account your wishes and your concerns. And if you're able to say what you want clearly, that guardian should do what you're asking in most cases. So you do have legal protections in the guardianship process.
Well, my daughter's just about to turn 18. Do I have to become her guardian?
I don't think you have to become her guardian just because she turns 18. I think it's a mistake to do that. As I was just saying to Sarah, guardianship's a legal proceeding, and lawyers are involved, and courts are involved, and it can be expensive. And there are a lot of alternatives to guardianship that people, I think, need to consider before they jump all the way to guardianship. So, for example, if there are medical decision-making issues, you might be able to become her health care representative, and that would allow you to make her health care decisions if she can't do it. If it's a financial issue involving Social Security benefits, you could become her representative payee, which means you would get the Social Security money and then you could use it on her behalf. So there are lots of alternatives to guardianship. And sometimes there's just informal types of decision-making assistance. Family and friends help out a person with a disability to make good decisions. So you really need to think carefully about whether the person needs guardianship, particularly just as they're turning into the age of 18. So you shouldn't do it unless you really think there are problems that only a guardian can solve, and not somebody or some other mechanism, such as I say, the health care representative, representative payee, or some other kind of alternative to guardianship. Okay. Well, I'm glad I was able to answer your questions. I really appreciate talking with you and meeting you, Sarah, and you, Tom, and thank you very much.
Thanks.
Thank you.
If you have additional questions or need more information about guardianship or other types of substitute decision-making, please visit our website at www.drnpa.org to access DRN's guide, Consent, Capacity, and Substitute Decision-Making, as well as other videos in this series.